Thank you very much, Mr. Chairman. Through you to the Honourable Attorney General, I note, thanks to Senator Allaha's indication during the debate, the definition of the word person as individual, company, etc. When we get to a later clause, we're going to treat with different species. We'll treat with an individual versus a company. I was wondering, I'm flagging for when we get there because I didn't want to pass this clause and not raise it here, whether we ought to consider the use of another definition in here, which is the inclusion of the word entity in exactly the formula that is used, in a modified formula that is used in the Securities Act, or whether when we get to the treatment of an offense by an individual versus a company, whether we'll be looking at other categories, unincorporated legal arrangements, etc. So, AG, just to point you to, so perhaps you could just flag it when we get to clause 4 and we get to the offense. It's at that point where we're disaggregating at subsection 13, where a person is an individual, and then where we go where a person is a company. So we haven't treated with the other types of legal arrangements. So I'm flagging it for there. So if need be, when you get there, you could reflect on clause 2.
Okay, so I'll take the point. I mean, I'm sorry that I was...
No, I know you've been in both houses, so I understand
both houses,
that. Yeah.
So I did not hear the argument. But of course, in law, we know that a person may be a natural person or an artificial person.
I got you.
So if you're flagging it now, I will pay attention to it when we come.
Thank you.
Later.
I flagged it because I knew you were in both houses, and I didn't want to say that it was said in the debate and it hadn't come to your attention.
Okay.
Thank you, Mr. Chairman.
All right. The question is that clause 2 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 2 now stands part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill.
Mr. Chairman, in clause 3, I'm just looking at the word emerging risks, and I'm wondering if that should instead be all, so that it may be an existing risk as opposed to an emerging risk only. It relates to the Commission's regulatory oversight.
Attorney General.
Chair, I think that is a useful point. We can take it because risk, of course, is broader than emergent risk. It includes emergent risk. So I accept that.
You'll have to move an amendment to incorporate.
So I could propose it this way, Mr. Chairman, and it doesn't necessarily have to be an amendment from me. It would be in clause 3 that the word emerging be deleted.
That we delete the word emergent in clause 3.
Clause 3 be amended by deleting the word emerging. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3 is amended by deleting the word emergent. In what section? In clause 3.1. So we can. That clause 3 as amended stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 3 as amended now stands part of the bill. Continue.
Clause 4.
The question is that clause 4 stand part of the bill. Senator Anwari, you wanted to raise?
Yes, Mr. President, thank you. Through you to the Honorable AG, specifically at clause 4, subsection 6. Subsection 6 is the disapplication for the individual who's not in the business of a virtual asset service provider. It says that nothing in subsection 1 shall prevent a person who owns a virtual asset from purchasing goods or services. That's fine. And B, from buying a virtual asset from another person or selling a virtual asset which he owns to another person. I'm inquiring as to the other manner in which you can treat property of that nature, mortgaging, pledging, etc. The reason being that I'm aware that individuals that own cryptocurrency, for example, leverage it by way of a mortgage or pledge abroad and obtain the forex to buy. So it fulfills the purposes of 6A. But if there is an express limitation, if there's a limitation that doesn't include the specific power to pledge, etc., that can happen. And I draw a reference, AG, we ran into this problem in several pieces of law where we had to define the word securities in the WASA Act and other positions. So from a mortgaging, pledging, or financing point of view, unless the express power is there, it will be viewed as not capable. So currently it's confined to only selling or purchasing the asset, that is the cryptocurrency, as opposed to the use in A, which speaks for itself.
In keeping with the policy, we do not wish to extend it to mortgages.
Okay. All right. The question is that clause 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause.
Because my copy is a little bit faint, I believed that the other question I had was the other question. May I, with your permission, please just raise an inquiry on subsection 9 of clause 4?
Okay.
Thank you so much, Mr. Chairman. Sorry to have missed that. Through you, Mr. Chairman, subclause 9, a virtual asset service provider which was in existence for a minimum period of 3 months before the coming into force, whether or not it is subsequently deregistered, wound up, or resolved, shall retain all business records, no issues. E, make the records, data, and transactions records available to the Commission or law enforcement upon request, insofar as they were not subject to production of records, being financial information within the meaning of the Data Protection Act specifically as sensitive personal information as defined there. It's in the subsection that says criminal or financial records. And insofar as it may be viewed to be private life information under Section 4 of the Constitution, I was wondering about the constitutionality for the compellability of this. I accept that a proportionate law doesn't necessarily need to have 3/5 majority for that. But I am aware that we had to contemplate the specifics of the Data Protection Act in the FATCA and EU regulations where we required 3/5 majority for this type of position. So I have a concern, and if you could please address it, AG, as to how the compellability of this without warrant in the face of a refusal will work.
I think that I'm not sure if those cases predated Surat, but the point now is that the Privy Council recognizes that you apply a proportionality test, and that practically all of these things involve some potential breaches of right, and that you look to see where the public interest lies. So I'm comfortable with it.
So
we did not flag it as requiring
So
a special.
I can confirm that they did predate Suraj, but they were based on Surat. I actually drafted the laws and passed them myself using the proportionality principles, except...
They predated Surat.
So the issue predated Suraj, which enforced Surat,
Yeah.
which is proportionality. But specifically, the issue was flagged when we were dealing with the EU package of laws to deal with the income tax and other amendments, etc., and the Exploitation and the Data Protection Act required us to do a 3/5 majority. So I'm concerned, my concern, I would have addressed this, if I could put it this way, by having, in default of that they could go for a warrant to get these, a simple amendment to this. And I can flag now, AG, that this is really the one issue that I've noted the amendment circulated that will come up a little bit later for the introduction of warrant, which takes care of the other main concern I had in the bill. I can't argue with the policy description that you previously had, but this is the one thing left in terms of compellability that causes me concern. Otherwise, I think that the rest of the bill is in good order.
I think we're okay on this, for the reason that I've set out.
Thank you. I won't argue the point, Mr. Chairman. I've noted it.
The question is that clause 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill. I think the Attorney General has an amendment.
So this is not this one. This one.
This is a typo in the sense that the clause appeared twice. So we are deleting it on page 17,
It's highlighted.
where it occurs in the second instance.
Mr. Chairman, I'm just finding it, not through any fault of the government, but because we're working with a printed copy of what went on, I unfortunately have some of the numbering mixed up in the print. I don't know, I had flagged earlier to the AG's attention the issue of a definition which would arise in a clause, and it's actually, I thought it was in clause 5, it's in clause 4. It's in clause 4, subsection 13.
My question has been settled.
May I, without revisiting the question, just for the record, so the AG can consider it after? I'm not looking for action on it. It's a very important point, Mr. Chairman, which I flagged earlier.
Well, as I said, we have already put the question center for salary, and we can't go back on that. Any Attorney General, any comment on the Attorney General's explanation as it relates to clause 5? The question is that clause 5 be amended as circulated. Huh?
Again, there's a little bit of a challenge with the formatting because we're having a difficulty in identifying the repetition that is being deleted. We're seeing 5 with subclause 1, 2, 3, etc. But in the version that we have...
Amendment says 5 where it appears the second time, which is on page 17.
after clause 18.
Right.
18.
The Attorney General has now explained. Okay. Okay. Yeah. Clause 5 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. Clause 5 as amended now stands part of the bill. All right. Clause 5 as amended, right? By, clause 5 as amended, right? Is it? Is amended as circulated by the Attorney General.
Mind telling us what that is? What I see is deleted where it occurs in the second instance. What is deleted? The repeat clause, I see.
Clause 5, where it occurs the second time.
I see.
After number 18
Right.
on page 17.
Okay.
I'm sorry about that.
No,
The
understood.
legislation was rushed
Yeah.
in the House below. And of course, that caused quite a,
No,
I'm not sure what the adjective would be.
understood. It's for that reason a little following is difficult.
Okay, let's, I think that thing was clarified, right, by the Attorney General. So let's put a question. Clause 5 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it.
Clause 6.
The question is that clause 6 stand part of the bill. Senator Courtney McNeish. You need
I think this matter was addressed when Senator Sirach Singh was winding up, making it very plain it's difficult to regulate beyond your own borders. I think this is the explanation he attempted to give. So, Mr. Chairman, I'm withdrawing this amendment.
Thank you. Right.
May I on clause 6, Mr. President? Mr. Chairman, thank you. In clause 7, subclause 3, sorry, 6, subclause 3, F as in Foxtrot, be a body corporate incorporated or continued in Trinidad and Tobago. I was wondering whether that should just simply be duly registered under the Companies Act of Trinidad and Tobago. And then in G, and that would be, I don't know if an external company is.
It might be continued but not incorporated.
Correct.
So I think that.
No, I got that. I was looking at the Part 5 external registry companies and the amendments we made to the Companies Act for non-profits, etc.
Yeah,
so
I would be slow to take out those two separate designations.
Okay, just laying it for the record, AG, I appreciate the anticipatory remark. Mine was duly registered. If I could just jump to the next one, just under there.
Sure.
And this may be answered by saying it is policy, not be currently subject to any regulatory or criminal enforcement proceedings. I was wondering about civil proceedings specifically because the Securities Act and the other AML laws also contemplate civil liability, but the Securities Act in particular, this parent act.
This is not the Securities Act, but what we're doing is seeing that it can't be, because there will be provision late at some point for the Securities Act. Isn't there provision for the Securities Act? There's a provision for the Securities Act.
Our thinking is that regulatory is used to distinguish it from criminal. So it could only be civil. I'm not sure that anything is added by adding the word civil to that.
Duly noted. I don't want to belabor the point. Thank you.
All right. The question is that clause 6 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 6 now stands part of the bill. Now there are no amendments between clauses 7 and 11, so we are taking those collectively. Okay?
Clauses 7 to 11.
The question is that clauses 7 to 11 stand part of the bill. The question.
Mr. Chairman, thank you. A question on clause 7. Clause 7, subsection 4, Roman 1.
You, Senator Alwari, will it only be, you know, I'm a Democrat. I try my best to accommodate without even written amendments. But I'm asking, outside of clause 7, are you going to be raising any further questions on clause 8, clause 9, clause 10, clause 11? Because I will have to give a ruling on the matter. Okay? So I'm just saying.
The answer is no to those.
All right, so
Yeah.
go ahead on clause 7.
Yeah, so on clause 7, clause 7, 4, Roman 1, provided a record of information that omits a material fact or contains a false declaration of a material fact. Is there any consideration as to having a mental intention of knowingly or without lawful excuse? Because omitting a material fact, I have no problem with a false statement of a material fact.
Yeah, we wouldn't want to go into that level of detail. That would be a matter for the Commission to determine what is material and not.
Okay.
So,
The question is that clauses 7 to 11 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 7 to 11 now stand part of the bill.
Clause 12.
The question is that clause 12 stand part of the bill. Senator Courtney McNeish.
Thank you, Chairman.
Clause 12.
I was concerned, AG, that when I examined the bill and I compared it to the Section 58 of the Securities Act, I saw no similar protection that is in the Securities Act, Section 58, in the current bill in its current form. And on my analysis, I cannot understand why this sort of provision offering some sort of protection to investors and clients, particularly when a provider is terminated or asks to cease operation.
What this bond does not have persons who bought equipment and who involved us, doing something that they loved.
Okay, so the technocrats agree that it should be part of the package. It's just that there are technical reasons, finance reasons why they feel it should be in regulations as opposed to the bill itself.
Yeah, I agree. And there's also this, the way the proposed amendment is worded, I can stay without being decertified just by refusing to fulfill my financial obligations.
Part. So, I didn't want to get into that, but that is what was whispered to me here, that we should put it into the regulations. Put it in.
Sure. Senator Courtney McNeish,
Yes.
would you like to?
Yes, sorry. I therefore withdraw the amendment, Mr. Chair. Sorry. Do apologize.
To the regs. You put it into the regs and you know what a commitment is.
The question is that clause 12 now stand part of the bill. Those in favor say aye. Those in favor say aye. Those against say no. I think the ayes have it. Clause 12 now stands part of the bill. The question is that
Clauses 13 to 15.
the question is that clauses 13 to 15 stand part of the bill. The question is that clauses 13 to 15 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 13 to 15 now stand part of the bill.
Clause 16.
The question is that clause 16 stand part of the bill. Attorney General.
Chair, I've circulated an amendment. I believe it, I was not here for Senator Arawi's contribution, but this deals with the question of amendment, warrants with consent,
With the
right?
permission of the sandbox participant.
Permission of the sandbox.
May I thank the Attorney General for the circulated amendment. It meets exactly with the concern raised. Thank you very much.
The question is that clause 16 be amended as circulated by the Attorney General. Those in favor say aye. Those against say no. I think the ayes have it. Clause what? Senator Vera?
Thank you, Chair. I just wanted to harken back to a point I think Senator Boodoo had made about the fee. It's at 16 about the charging of a fee as may be prescribed for the compliance review. That seems a little self-serving. And I have to say that I've had experience with the Securities and Exchange Commission where they were charging very hefty fines for persons under their jurisdiction not filing audited reports when those persons had no control over the audited reports that were being made to file. And so I have a little concern that this could be problematic.
Colleagues, we'll have to suspend in order to conduct a procedural motion at this time. Business.
Thank you. Mr. President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand, inclusive of any matters on the adjournment for which there are none.
Honorable Senators, the question is that the Senate continue to sit until the completion of the business at hand, inclusive of any matters on the adjournment. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The business of the Senate will continue until the completion of the matters before it. Be resolved into committee. You want to refer to, or respond, I should say, to Senator Vera?
The question of fine, Senator Vera, I believe that that is subject to some sort of administrative review, which would be dealt with, as I understand it, given the structure of the legislation, in regulations which would be subject to negative resolution.
No, I take your point. It's an administrative fee. And the reason why I'm not going to pursue the point is because it mirrors the same wording that already exists in the Securities and Commissions Act. So although I've had a concern, there's nothing I can do about it, so I accept it.
The question is that Clause 16 be amended as circulated by the... Clause 16 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Mr. Chairman, for your
Clause
ease,
16, Clause 16, as amended, now stands part of the bill.
for your
Yes,
ease, Mr. Chairman,
Attorney
I only have concerns on 20 and 23, subject to anyone else, of course.
Okay, cool. Thank you. Yes, go ahead. So we'll take clauses 17. Proceed with clauses 17 to 19.
Clauses 17 to 19.
The question is that clauses 17 to 19 stand part of the bill. The question is that clauses 17 to 19 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 17 to 19 now stand part of the bill.
Clause 20.
The question is that clause 20 now stand part of the bill. Senator Alwari.
Thank you, Mr. Chairman. Through you to the AG. Clause 20 mirrors almost exactly Section 19 of the Securities Act, which is the cooperative arrangements with the central bank and other agencies. It only deviates at subclause 3. Subclause 3 is that the Commission may enter into a memorandum of understanding with any agency referred to in subsection 1 and any other regulatory body in furtherance, etc. However, these are the words that are not in the Securities Act. However, the absence of such memoranda shall not prevent the Commission from sharing information.
Is disturbing the proceedings? Oh, is an alarm? Okay. Okay, I understand. I understand. There's a challenge. It happened to me as well. Okay, let's continue.
Thank you. So Mr. Chair, just quickly,
Yeah,
AG, the language at subclause 3,
Yeah.
that is, however, the absence of such memoranda shall not prevent the Commission from sharing information with the persons or entities mentioned under subsections 1 and 2. I had concern with that because it's beyond the width of the Securities Act and it goes beyond subsection 1 and includes subsection 2. This is 20, clause 20, 20, which was
Clause 20,
which was 10 renumbered. It's under miscellaneous part 4.
Beyond 20.
The one that I printed off, Mr. Chairman, says 20. So forgive me then, it is on electronic version I see here is 22. So I'll stand down to then. Please, Mr. Chairman, apologies.
So we'll move on. Okay. The question is that clause 20 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 20 now stands part of the bill.
Clause 21.
The question is that clause 21 stand part of the bill. Attorney General, I think you have an amendment.
Okay. Chair, again, there's an amendment as circulated. We're asking that 21(2) delete where it occurs in the second instance. It's repeated, 21(2) and then 21(2).
Members understand what the Attorney General has explained? So let's go again. The question is that clause 21 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 21 is amended, as amended, now stand part of the bill. Those, yes, okay. Those in favor say aye. Aye. Those against say no. The ayes have it. Question 21 as amended now stands part of the bill.
Clause 22.
Thank you, Mr. Chairman.
The question, no, just one second.
Sure.
The question is that clause 22 stand part of the bill. Senator Alwari.
Thank you, Mr. Chairman. Through you to the AG, subclause 3, 1 and 2 are almost in keeping with the Securities Act, specifically Section 19. Yeah, so they're nearly identical for all material purposes, save for subclause 3, those words which are in bold. However, the absence of such memorandum shall not prevent the Commission from sharing information with persons or entities mentioned under subsections 1 and 2. That is not a feature of the Securities Act. And because subsection 2 is also not referred to in the Securities Act, and that is much broader, it includes any person who's other than an employee who acts on behalf or provides services to the Commission, it widens the disclosure considerably. So my recommendation for your consideration is to delete those words in bold to bring it in line with the Securities Act word for word, particularly in the reference to subclause 2 category of persons.
So there is a rationale for it. The policy is that this act has more of an international flavor and is meant to allow for greater international cooperation than the domestic legislation. So the words are policy, and we wish to keep those words.
Thank you for the explanation. Obviously, for the record, I don't agree with it, but it's not a time to engage in policy debate. Thank you, AG.
Question is that clause 22 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 22 now stands part of the bill.
25, Mr. Chairman. 25, not 25.
25, okay. So we'll deal with clauses 23 and 24 jointly.
Clauses 23 and 24.
The question is that clauses 23 and 24 stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 23 and 24 now stand part of the bill.
Clause 25.
The question is that clause 25 stand part of the bill. Senator Alwari.
Thank you, Mr. Chairman. Through you to the AG, I appreciate the need for clause 25. It's to meet the recommendations for recommendation 35 for administrative sanctions for the FATF. My concern is that, albeit that it applies AML CFT administrative positions for other laws, it doesn't provide an administrative sanctions route for these laws, meaning these summary offenses, etc. So normally you would set up, if somebody is guilty of a summary offense or an offense in the schedule, and then the notice is presented to them, then they have the opportunity to enter into an administrative fine, and if they don't pay the fine, then the charge is restored. So none of these offenses here are catered for under the recommendation 35 route. So I was flagging for you, just for the record, I don't suppose that you'd be able to deal with it tonight, that the recommendation 35 formula for the offenses in this act ought to be considered.
I'll look at it.
Thank you.
But like it is.
This is 20.
Clause 25 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 25 now stands part of the bill.
Clauses 26 and 27.
The question is that clauses 26 and 27 stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 26 and 27 now stand part of the bill.
Clause 28.
The question is that clause 28 stand part of the bill. The Attorney General.
Sure. As circulated, Chair, in item headed Proceeds of Crime in the second column, in paragraph D, we want to delete subparagraph Roman 5 and 7.
Be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 28 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 28 as amended now stand part of the bill.